court. All right, Mr. Prieto, ordinarily I would be admonishing you with my probation officer, Marcella, on the stand, that as soon as you book out of the jail to report directly to the probation department. But the problem is I have no idea whether you're going to be booking out of the Smith County Jail or whether or not you're going to be transported back to Collin County. That's not up to the court. If you remain in custody until Collin County comes and picks you up on the assault they have apparently pending up there that's reflected in the pre-sentence investigation, after your case is disposed of in Collin County, you would be ordered as a term and condition of your deferred adjudicated probation to report back down here to the probation office in Smith County. Now, what's going to be very difficult for the court to do is to give you a date as to when that takes place. I can tell you this, if you do not go back to Collin County and you're released because Collin County drops their assault up there because you've been placed on deferred adjudicated probation, if you don't have to go back to Collin County, when you book out of the Smith County Jail, it's the #1 condition of your deferred adjudicated probation in both cause numbers for you to report directly to the Smith County Probation Office to meet with your supervising probation officer. Do you understand that?
Yes, sir.
You want to go ahead and explain to him as best you can, Marcella, if he books straight out of jail, that's only going to happen if Collin County dismisses their charge. But go ahead.
Mr. Prieto, immediately upon being released from Smith County Jail or Collin County Jail, immediately report to the Smith County Probation Department, which is the same place that you were reporting to pretrial. When you get to the probation department, you're going to sign a new from court and you'll be assigned an intensive supervision officer.
Do you understand all that, Mr. Prieto?
Yes, sir.
So if Collin County releases their hold and they're not going to come get you and take you back to Collin County, then when you book out of the Smith County Jail, number one, you wouldn't book out if Collin County still has a hold on you. So if you book out of the Smith County Jail, that's going to likely mean Collin County's dropped their hold. So when you book out, you have to do just what your court's probation officer said. When you book out of jail, you have to report directly to the probation department. Do you understand where the probation department is located?
Yes, sir.
If you do not report directly to the probation department, the probation department, as well as Ms. Anderson, they'll all know if you don't report directly because it'll show a book out time. And if you're not down at the probation department within about 15 minutes from the time you book out of the Smith County Jail, they'll just file a violation report and we'll go start all over. I'll issue no bond warrants for your arrest. You with me on that?
Yes, sir.
If somehow Collin County comes and gets you and takes you back to Collin County on this misdemeanor warrant, then the way the condition will read is once you dispose of your case in Collin County, you have to immediately report back down here to the Smith County Probation Office the next day. You follow me on that?
Yes, sir.
Those are all conditions of your probation. If you violate any of those probation conditions, including the 70 or so your probation officer is going to go over with you, if there's any violations, I'll issue no bond warrants for your arrest. Once you're apprehended, whenever that is, then the state can go forward and proceed to seek final adjudication because you violated your conditions, one or more of them. So that's a hearing before the judge. And then if the court determines you violated your deferred adjudicated probation by failing to report or any other condition, the court will grant the state's motion to adjudicate, go back and find you guilty of the offensive assault on a peace officer's alleged in each indictment. Then in each case, the judge can assess your sentence up to 20 years in Texas Department of Corrections Institutional Division, fine of up to $10,000. You understand all that?
Yes, sir.
Do you have anything else, Mr. Roberson?
No, Your Honor.
Are you satisfied with the legal representation that you've been provided by your court-appointed attorney, Mr. Roberson?
Yes, sir.
Anything else, Ms. Anderson?
No, sir.
All right, we are going to go off Zoom in this case, but I need to hang on to Mr. Marcella. You got all this because obviously it'll pop up on your computer when he books out of jail. Be sure he's at the probation department. Otherwise, file a violation or file sign 2 bonds for violations for no bond warrants, and we'll start all over. Okay.
Yes, Your Honor. And this case will be assigned today to an intensive supervision officer so we can keep up with this case, Your Honor.
That's a good idea. Thank you. All right, we're going off the record and off Zoom on this case. I'm just going to take this opportunity, if I can hang on to Mr. Roberson and Ms. Anderson on the previous case, just from the standpoint of it appeared, and so you both know where we're going, which you know anyway. I'll have to have that defendant examined by Dr. Proctor. I'll either have to have him transported to Dr. Proctor's office in custody, or Dr. Proctor will come down here, which is more likely with that defendant. The Dr. Proctor will come down here and examine him to determine whether or not he is competent to waive his right to counsel. I mean, I'm not telling you, y'all well aware of that. I just wanted to put it on the record. That's what's getting ready to take place.
Yes, Your Honor.
Yes, sir.
All right. We're in recess on this case and the 2 where the defendant is in jail, and Dr. Proctor will have to come down. This is, the previous one I'm talking about, Mr. Robertson, the defendant was on camera, talked to some length. So that's going to obviously trigger, based on where the court is in the case. I'll have Denise contact Dr. Proctor and set up a time for him to be examined, I would imagine, by Dr. Proctor in the Smith County Jail. And once I get that report on competency, we'll go from there.
Thank you, Your Honor.
All right, we're in recess.
Hey, they said something about they're in recess. Does that mean that I'm through, or do I have to be dismissed by that? That's why I'm kind of,
Mr. Prato. Oh.
Yes, sir.
Hang on a minute.
After the bring Mr. Climax.
No, we need Taylor Green.
I mean, Taylor Green, I'm sorry.
Okay.
Are you Taylor Green?
Yes, ma'am.
Thank you. Do you live in Smith County?
No, ma'am.
Where do you live at?
In Jacksonville.
In Jacksonville? Okay,
Yes, ma'am.
thank you.
All right, let me get this on the record here. Here we go. We're on the record. Now, this is an unindicted case, State versus Taylor Green. Taylor Green is on Zoom from the jail. His attorney, Mr. Roberson's on Zoom from his office. Ms. Anderson's on Zoom from her office, assistant district attorney. All right, court's calling cause number. Well, it's not, obviously it has no indictment number yet. State versus Taylor Green, application for writ of habeas corpus seeking release because of delay under Article 17.151. Let me see what I've got here in the file. Okay, it looks like understandably, all I've got in the file is Mr. Roberson's application for a writ of habeas corpus seeking release because of delay under Article 17.151. All right, and Ms. Anderson's on the screen. Go ahead, Mr. Roberson. Defendant's on the screen. Taylor Green.
Judge, it's my understanding that Mr. Green was incarcerated on May the 25th of 2021 for evading a vehicle and possession of controlled substance. The bond was in an amount of $10,000 and $5,000. He has not been indicted for those charges. So my understanding, the 90-day period has passed, and under 17.151 of the Code of Criminal Procedure, he's entitled to a PR bond or bond reduction. I can inform the court that it's my understanding that the Cherokee County has a hold on him. If the court grants these PR bonds, my understanding Cherokee County is supposed to come pick him up, take care of his business in Cherokee County.
What's the Cherokee County hold for?
They were for a drug charge, and I think it was a couple of drug charges and something else. There was like 2 or 3 felonies, Your Honor.
All right, let's see. What, Ms. Anderson, what's your charge?
So, Ms. Judge,
I'm sorry, all I've got in front of me, reason I'm asking, all I've got in front of me is Mr. Roberson's application.
Judge, Mr. Green has 100 days in jail today, and Mr. Roberson's correct. An indictment has not been returned within the 90-day period, and so he is entitled. Mr. Green is entitled to a PR bond or reduction in bond. He does have Cherokee County holds on him. Those are felony holds for drug charges and an evading case. And so, upon release, I do believe he'll be transported directly to Cherokee County.
All right, let me see. All right. Taylor Green was arrested for the offense of evading arrest or detention with a motor vehicle possession of controlled substance on May the 24th, 2021. Continuously confined in Smith County Jail on this charge since that time. Unable to make bonds of $10,000 and $5,000. More than 90 days have passed since the defendant was arrested and incarcerated, correct?
Yes.
Well, obviously, the court grants through Mr. Roberson, the court grants the defendant's application for writ of habeas corpus seeking release because this offense has not been indicted within 90 days of the date of arrest. Therefore, the defendant being entitled to personal recognizance bond, bonds are presently set at $10,000 surety bond, $5,000 surety bond. Court is obviously going to grant as the court's mandated to do, grant the request in order that the $10,000 bond and $5,000 bonds now are converted to personal recognizance bonds. Anything else, Mr. Roberson?
No, Your Honor.
Ms. Anderson, I would imagine that Denise will. This is where I'm trying to get this done, I suppose, best I can. He's entitled to PR bonds, but he needs to sign those personal recognizance bonds. Even though they're PR bonds, he has to sign them with conditions. So I'll leave it to you, Ms. Anderson, to get that done at the jail before they'll notify, Cherokee County?
Yes, Your Honor.
Would you just get that done, Ms. Anderson, at the jail where he'll have to sign personal recognizance bonds? I'm sorry, PR bond on this case. And that way he'll be on a PR bond. Then Jacksonville will pick him up. I think you said on more serious charges anyway.
Yes, Your Honor.
He's got right now, Ms. Anderson, he's got a $10,000, $5,000 bond. So the court will just continue those. He'll be released to Cherokee County. And since he hadn't been indicted within the 90 days, but has he been indicted now?
He has been indicted now, Your Honor, but we don't have cause numbers yet. And as I said, it was outside of the 90-day period.
Yeah, that's fine. I just wanted to put that if there were cause numbers, get it in the record. But anyway, defendant's writ's granted. He's ordered release from Smith County Jail. On a PR bond, Ms. Anderson, would you be sure that when the jail releases him, they have had him sign conditions on the PR bond?
I will do the best I can to ensure that the jail does that, Your Honor.
That's why I'm leaving it to you.
Yes, sir.
All right, anything else, Mr. Roberson?
No, Your Honor.
All right, writs granted. If you need an order, Mr. Roberson, send me one. Maybe you got one in here.
It should be one e-file, Your Honor.
Well, Denise probably has it. If I've got one, I'll sign a PR bond in the amount of 10,000 and 5,000, one for evading, the other for PCS. I'll get Denise, get that drawn up, and then PR bonds are granted due to the knowing, I'm sure there's good reason, but no indictments within 90 days. All right, anything else, counsel?
No, Your Honor.
All right, Mr. Green,
Yes, sir.
you're going to be released from the Smith County Jail, but you're going to be released from the Smith County Jail into the custody of Cherokee County officers. Do you understand that?
Yes, sir.
Those Cherokee County officers will take you back down to Jacksonville, Cherokee County, to answer the charges down here. In the
Okay.
meantime, you're going to still have did you say the grand jury had returned indictments, Ms. Anderson? I'm sorry.
Yes, sir.
So you're going to still have up here, Mr. Green, Mr. Roberson will still be your attorney up here in Smith County, which will be good. You still have the two indictments pending up here in Smith County. And although you're released on the PR bond, obviously you understand the state can and probably will prosecute you for evading arrest or detention and for PCS. You with me on all that?
Yes, sir.
Okay, and that PR bond is going to have a date in it, and it's going to have conditions in it that you have to follow, and that'll all be explained to you. And be sure you understand all the conditions, because even though they're personal recognizance bonds, what will take place is if you violate any of the conditions of your personal recognizance bond up here in Smith County for evading in a vehicle and PCS, the state will file a motion and I'll sign an order revoking the PR bonds, issuing warrants for your arrest, and I'll set a new bond, which I'll sure you'll be hiring 10,000 and 5,000. You with me?
Yes, sir.
All right. Anything else, Ms. Anderson? Anything else?
No, Your Honor.
Okay. Anything else, Mr. Roberson?
No, Your Honor, but I do stay in contact with his mother. She calls me on a daily basis, Your Honor.
I'm sorry, what, Mr. Roberson?
His mother calls me on a daily basis, so she stays in contact with me.
Well, that's good news. That'll help. We're in recess. Do we have anything else, Ms. Anderson?
No, sir.
Okay. I'm gonna sign an order for a comps examination on that other case. Oh. No, that was on which one? Along that, they rejected that. Oh, that's where I gotta get it sent out. I gotta get it sent out about the process of the chat. Well, I got to say, it won't be making all that. Mr. Robertson?
Yes,
Can you
Your
hear
Honor.
me? Okay, this isn't on this case. It's one of those prior cases where I'm ordering a competency examination by Dr. Proctor. I'll be signing the order today. Denise did say she's probably got 6 or 7 in front of it to be examined by Dr. Proctor. So, I can't tell you for sure when he'll get to this one, but I'll sign an order today for him to be examined by Dr. Proctor.
Yes, Your Honor. Thank you.
All right. All right, this is in cause number 2410700-13, State versus Aaron Climax. It's on a motion to adjudicate guilt. Ms. Anderson's present, Mr. Roberson's present, Aaron Climax is present from jail. You want to waive the formal reading and presentation of the state's motion to adjudicate, Ms. Anderson?
Judge,
Yes,
wait
sure.
the formal reading of the state's motion to adjudicate. And his name is correct. It said forfeit the motion. Judge, we've gone over the allegation. He's going to enter a plea of true to all the allegations, Your Honor.
Well, if this wasn't on Zoom, I'd say something like, "Well, I thought you were representing this defendant too, Ms. Anderson," but I won't. It won't be in the record. I couldn't resist it. It's old habits from an old judge. Too many years in the past. All right. Cause number 2410700-13, State versus Aaron Climax. It's going to be on the state's motion to adjudicate guilt. You want to waive the reading and presentation of the motion, all the other formalities, Mr. Roberson?
We do, Your Honor.
All right, Mr. Climax, do you understand all the allegations in the state's motion to adjudicate guilt, which allege violations of your deferred adjudicated probation?
Yes, sir.
Did I swear you in?
Yes,
I don't
sir.
think you did, Your Honor.
No, Your Honor.
Raise your right hand because I was in a hurry to get that in the record and I think I forgot. Do you solemnly swear the testimony you'll give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, 2410700-13. That's on the state's motion to adjudicate guilt. Go ahead, Ms. Anderson, on your motion.
Your Honor, I believe we have an agreement for 5 years TDC on the revocation.
That
All
is
right.
correct, Judge.
That's okay. That's the bottom line is, Mr. Roberson, you and Mr. Anderson the court will grant the motion to adjudicate. Agreed?
Yes,
You
Your
don't,
Honor.
you don't need a hearing on the motion to adjudicate, correct?
No,
No,
Your
sir.
Honor.
All right, court's granting the state's motion to adjudicate. Court having granted the state's motion to adjudicate, taking judicial notice of all the prior proceedings, the court does, based on the defendant's earlier plea of guilty to the offense of burden of habitation of second-degree felony as alleged in the indictment. At that time, the court had followed the state's recommendation, withheld a finding of guilt, placed the defendant on deferred adjudicated probation. Now, the state has filed a motion to adjudicate guilt on June the 19th, 2021, which allege violations of the deferred adjudicated probation the defendant was serving for the offense of burglary of habitation. Second-degree felony is alleged in the indictment. If you look on the screen, Mr. Climax, you see that written plea admonishments and stipulations of evidence?
Yes, sir.
Okay. Have you been over that written plea admonishments and stipulations of evidence with Mr. Roberson, your attorney, so you understand it?
Yes, sir.
Okay, so you do understand the allegations being made by the state that allege violations of your deferred adjudicated probation. Is that correct? All the paragraphs, is that correct? Here's what you say. Signed and now sworn to. The defendant whose signature appears below and who appears in person before the court, you're appearing before the court by Zoom, is the same person as originally placed on community supervision probation in this cause. Court makes that finding. 2, you tell me under oath that the allegations as set out in all the paragraphs of the state's motion to proceed to final adjudication are true. And you, with your attorney present, Mr. Roberson, you are entering pleas of true to all the allegations which allege violations of your deferred adjudicated probation as alleged in the state's motion to adjudicate guilt. Is that correct?
Yes, sir.
This document you signed and now sworn to, you can see that right in number 2. The allegations are set out in all the paragraphs of the state's motions you adjudicate are true and that you are entering pleas of true with your attorney present to all the allegations which allege violations of your deferred adjudicated probation in the state's motion to adjudicate. Is that correct?
Yes, sir.
And you understand you signed this document and now sworn to this document freely, intelligently, knowingly, and voluntarily. Is that correct?
Yes, sir.
The document provides up top, state's exhibit. It's a state's exhibit.
Number 5.
Yes. Yes,
I don't
it
know.
is. Okay. It's state's exhibit. Here's, let me go over these written plea admonished stipulations of evidence. You've signed it. You can see them on the screen. Your is that your signature on the line above where it says defendant signed Aaron Climax?
Yes, sir. That's my
All
signature.
right. Do you understand the document, the written plea admonishments and stipulations of evidence? It gives you 4 admonishments, explanations, and then it says understanding those admonishments and understanding the allegations by the state in their motion to proceed to final adjudication. Those are allegations that you violated terms and conditions of your deferred adjudicated probation. Do you understand that?
Yes, sir.
Then you tell me you make the following free, knowing, intelligent, and voluntary stipulations of evidence, and I've sworn you in. You tell me that you're the same person who was placed on deferred adjudicated probation in this cause number. Then you tell me that the allegations, and you can see it on the screen, that the allegations is set out in all the paragraphs of the state's motion to adjudicate. And those are allegations in all the paragraphs that allege violations of your deferred adjudicated probation. Do you understand that?
Yes, sir.
And then you say all those allegations alleging violations of your deferred adjudicated probation are true, and that you, with your attorney present, are entering pleas of true to all the allegations in the state's motion to adjudicate, which allege violations of your deferred adjudicated probation. Is that correct?
Yes, sir.
Are you entering these pleas of true freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, the court does receive and accept your pleas of true. The court does approve the written plea admonishments and stipulations of evidence signed and sworn to by the defendant. And you understand you sworn to this document, Mr. Climax?
Yes, sir.
Did he swear to it, Ms. Anderson?
You swore him in, Your Honor.
All right. Just wanted to be sure. All right. Go ahead, Ms. Anderson.
Your Honor, we'd offer states 5, the plea admonishments.
No objection, Your Honor.
With no objection, states 5, the written plea admonishes stipulations of evidence submitted into evidence without objection approved by the court. Court having admitted into evidence with no objection, the written plea admonishments, stipulations of evidence, court does find all the allegations in the state's motion to adjudicate, which allege violations of the deferred adjudicated probation assessed the defendant at an earlier date. Court finds all those allegations true, grants the state's motion to adjudicates the case, finds the defendant guilty of the offense of burglary of habitation, second-degree felony as alleged in the indictment. For sentencing.
Your Honor, we have an agreement for 5 years confinement in the institutional division.
Okay,
That's
Mr. Robertson. 5 to do. Court
Yes, sir.
follows the agreement. Having granted the state's motion to adjudicate, having found the defendant guilty of the offense of burglary of habitation, second-degree felony as alleged in the indictment, the court assesses the sentence at 5 years in the Texas Department of Corrections Institutional Division. No fines assessed, court costs are ordered paid. Any restitution, Ms. Anderson?
No, Your Honor.
No restitution is indicated as due. Sentence is formally pronounced by the court. Granting the state's motion to adjudicate, the court finds the defendant guilty of the offense charged in the indictment, burglary of habitation, second-degree felony, follows the agreement, assesses the sentence at 5 years in the Texas Department of Corrections Institutional Division, assessed with credit for time served. Waiver of appeal is accepted by the court. You understand you're waiving, giving up your right to appeal, Mr. Climax?
Yes, sir.
Your waiver of appeal, waiving your right to appeal, and waiver of your right to file a motion for new trial, those are approved, accepted by the court order to file the papers of cause. It'll be the order of the court now, Mr. Climax. You're continued in the custody of the sheriff until you can be transported to Texas Department of Corrections Institutional Division to serve the 5-year sentence assessed by the court with credit for time served. Are you satisfied with your court-appointed attorney, Mr. Roberson's representation?
Yes, sir.
All right. Anything further, Ms. Anderson?
No, sir.
Anything further, Mr. Robertson?
No, Judge, I was retained by Mr. Climax.
Oh, I'm sorry, Mr. Robertson. That threw me for a loop. I retract that question, which now I don't need to ask whether or not you're satisfied, because the record reflect Mr. Clifton Robertson was hired by you and is your personal retained attorney. So that last question is withdrawn by the court. All right, Ms. Anderson, do you have anything else?
No, sir, not on this defendant.
Okay, we're in recess. Oh, goodness gracious. Is this Clifton's day?
Mr. Climax, just wait just a second. We're gonna see who's next, where you can let the jail staff know who's next, okay?
We'll
Yes,
need
sir.
Chauncey Johnson.
Chauncey Johnson.
Haven't they just brought Chauncey Johnson's files in here?
Okay.
Is that who's on the screen?
Not yet, Your Honor.
Well, that's what that's what Tabitha said. Okay. Okay, we're looking for Chauncey Johnson.
Yes, sir. That's me.
All right, got him on the screen here in front of us. Got two cases, calls number 24105 2721, 24105 2821. Both state versus Chauncey Johnson. First indictment charges possession of controlled substance less than a gram. Next indictment 052821 charges prohibitive substance in a correctional facility. Third degree felony is alleged in the indictment. Court has plea agreements on both cases, indicating on 2410527-21 possession of controlled substance less than a gram. State's recommendation there is 7 months in a state jail facility with credit for time served. Is that the plea agreement on that one?
Yes, sir.
Okay, that's good, because it's your agreement. Is that it, Mr. Robertson? 7 months?
That is correct, Judge. It's mandatory probation, and he's waiving the mandatory probation, Your Honor.
Okay, is that correct, Ms. Anderson?
It is, Your Honor.
All right, Mr. Johnson, you understand what Mr. Robertson just said. I have to cover with this with you for the record. You understand this is a mandatory probation case, the charge of possession of controlled substance less than a gram state jail felony. Court's mandated to assess you a probated sentence. However, in this case, you have agreed, rather than to take a probated sentence, you've agreed to take a sentence of 7 months in a state jail facility with credit for time served. Is that correct?
Yes, sir.
All right, on the other indictment over in 0528-21, where were you charged with prohibited substance in a correctional facility? The plea agreement there is, if you enter a plea of guilty to that indictment, the state's recommending your sentence at 2 years in the Texas Department of Corrections Institutional Division. That would be ordered to run concurrent or at the same time with your 7 months in a state jail facility. Are those your plea agreements?
Yes, sir.
All right, you've got a set of plea documents in both cases. The plea documents are the same. They're just different based on the particular offense involved. In 241-0527-17, as well as 241-0528-21, in both these, on the possession of a controlled substance less than a gram, as we've already talked about, if you plead guilty, the court's going to assess your sentence at 7 months in a state jail facility with credit for time served. You understand that?
Yes, sir.
Then pursuant to a 1245 agreement, the court will consider a DA number 20-04055, I think it is, and then a DA number 2101281 for criminal trespass. It looks like maybe a possession of drugs in the other one. Anyway, the court needs to ask you, do you admit and acknowledge your guilt to an offense of criminal trespass under DA cause number 2101281?
Yes, sir. I guess so. I was my mind on that one.
Hold on, stop right there. The court's taken those two into consideration pursuant to Article 1245, which means these two offenses are being considered in the assessment of the sentence by the court for 7 months in a state jail facility and 2 years in a state jail facility. So Ms. Anderson's going to dismiss as part of your pleas on both these cases. Those two offenses under DA cause number 2101-281, which looks like criminal trespass, then 20-04055, possession of dangerous drugs. Those are going to be dismissed by the state on your pleas in both these cases. Do you understand all that?
Yes, sir. Thank you.
All right, then on 2410527-20, your plea is if you enter plea of guilty, state's going to recommend 7 months in a state jail facility. Over in the other one, 2410528-21, if you enter plea of guilty to prohibited substance in a correctional facility, that's a third-degree felony. The state's going to recommend, the court's going to follow it, 2 years in Texas Department of Corrections Institutional Division. That'll be assessed with credit for time served. You would be ordered to pay on that one restitution due to the Department of Public Safety for the assessment. For the analysis of the controlled substance. That's your plea agreement on that one, Mr. Johnson.
Yes, sir.
All right, I'm going to go through now and just ask you some questions for purposes of your pleas. And the questions I'm asking are for your pleas to the indictments in both cause numbers 2410527-21 and 2410528-21. Do you understand that?
Yes, sir.
All right. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcohol in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything about the facts of each one of these cases and everything you're doing in court today on each case with your attorney, Mr. Roberson?
Yes, sir.
Competent, Mr. Roberson?
Yes, Your Honor.
Any evidence of incompetence, Ms. Anderson?
No, sir.
Court notes State's counsel signed her consent to approve waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in each case signed sworn to by the defendant, signed by the defendant's attorney. All right. Do you understand all the allegations and the charge in the indictment in each cause number? 052721 is a charge of possession of a controlled substance less than a gram. 052821 is a charge of prohibited substance in a correctional facility, a third-degree felony. So to be sure you understand the question, do you understand all the allegations, the charge in each indictment, the full range of sentencing, and all your plea papers?
Yes, sir.
Do you have any questions about either one of those for the court?
No, sir.
All right, in cause number 2410527-21, what is your plea today to the indictment charging you with possession of controlled substance, a state jail felony? Like, what is your plea, guilty or not guilty?
Guilty.
In cause number 2410528-21, what is your plea today to the indictment in this cause number charging you with prohibited substance of controlled substance in a correctional facility, third-degree felony?
Guilty.
Are you entering your pleas of guilty to the indictments in each cause number today because you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you in any way, promised you anything, or coerced you to enter either plea of guilty?
No, sir.
Are you entering your pleas of guilty to the indictments in each cause number today freely, intelligently, knowingly, and voluntarily because you committed the offense charged in each indictment?
Yes, sir.
Are you entering your pleas of guilty to the indictment in each cause number today as a result of any type of delusion or unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty to the indictment in each cause number. What do you have, Ms. Anderson?
In each cause number, we'd offer states 1, the plea packet with signed waivers and admonishments, states 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
Court approves in each cause number, states exhibit 1, all the plea papers, states 2, the signed sworn to stipulations of evidence, states 3, discovery compliance. All approved by the court. State exhibits 1, 2, and 3 are admitted into evidence in each cause number without objection. The court finding the defendant's waiver of his rights to execution of all these documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment, and each cause number was entered by the defendant to the indictment, and each cause number freely, intelligently, knowingly, and voluntarily. The court, having received and accepted the defendant's plea of guilty to the indictment in each cause number, the court does find the defendant guilty of the offense alleged against him in each cause number. That is, in cause number 2410527-21, the court does find the defendant guilty of the offense of possession of a controlled substance, state jail felony. And in cause number 2410528-21, the court does find the defendant guilty of the offense of possession of a controlled substance in a correctional facility, a third-degree felony. In the court following the plea agreement in that case assessed the sentence at 2 years in the Texas Department of Corrections institutional division. The seven, any legal reason for formal final sentencing?
No legal reason, Your Honor.
99, the court does formally pronounce the sentence. Cause number 2410527-21. Court finds the defendant guilty of the offense of possession of controlled substance, state jail felony. Follows the plea agreement, assesses the sentence at 7 months in a state jail facility. The court has considered under 1245 an offense under DA number 2101281 for criminal trespass, and under DA number 20-0405 for possession of dangerous drugs. Those have been considered by the court under 1245, so they'll be declined or dismissed by the state. Over in the other cause number, prohibits substance correctional facility 052821, third-degree felony. The court follows the plea agreement, receives and accepts the defendant's plea of guilty, finds the defendant guilty of the offense of prohibited substance in a correctional facility, third-degree felony, follows the plea agreement, assesses the sentence at 2 years in the Texas Department of Corrections institutional division, assessed with credit for time served. The 2 years in the Texas Department of Corrections institutional division, credit for time served, ordered to run concurrent at the same time as the 7-month sentence assessed in 0527-21 with credit for time served. Just for the record, on the plea papers in 2410528-21, it is clear to the court, apparently initially there may have been some type of agreement initially for deferred. That's clearly been marked out initial by Mr. Roberson, reflecting the 2 years minimum for the range of sentencing for the possession of controlled substance. Courts followed the plea agreement, says 2 years in Texas Department of Corrections institutional division with credit for time served. Mr. Johnson, do you understand in both these cases, you have filed with the court waivers giving up your right to appeal and waivers giving up your right to file a motion for new trial?
Yes, sir.
Are you waiving both those rights in both cases freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Are you satisfied with the legal representation of your court-appointed attorney, Mr. Roberson?
Yes, sir.
All right, it'll be the order of the court, Mr. Johnson. You'll continue the custody of the sheriff until you can be transported to the state jail facility and serve the 7-month sentence with credit in cause number 2410527-21, and until you can be transported to Texas Department of Corrections institutional division, serve a 2-year sentence with credit for time served for prohibited substance in a correctional facility, a third-degree felony. Court's ordering both sentences run at the same time, concurrent with credit for time served. You'll be ordered to pay a $180 lab fee as part of the sentence on your third-degree prohibited substance in a correctional facility. That's part of your plea agreement. And you are satisfied, of course, with Mr. Roberson as your court-appointed attorney, correct?
Yes, sir.
Ms. Anderson, have I missed anything?
Not that I can hear, Your Honor.
That's a good answer. Do you have anything, Mr. Roberson?
No, Your Honor.
Okay, we're in recess to finish in custody until he can be transported to a state jail facility and or the Texas Department of Corrections to serve the sentences assessed by the court, both running with credit for time served, waivers of appeal accepted. We're in recess on both these cases.
Hey, Mr. Johnson, hang around till we see what the next person is where you can let the bailiff know, okay?
Yes, sir.
We'll need Jordan Jones.
Jordan
George
Jones.
Jones.
Yes, sir. Thank you all and God bless.
Yes, sir. Good luck.
You too.
Same to you. Ms. Anderson, do you have another one?
Your Honor, we still have 3 more pleas to take this morning, but they're all for time.
Okay. We get the next file here. There you go.
I'm supposed to put it there. No, you weren't. Go,
Okay.
Hey, Mr. Jones next?
Yes,
Okay, I do.
Jordan Jones.
Ms. Anderson,
Sir,
I was just thinking, I don't know how many pleas we've got, how many pleas we've been through. I think we've got 3 more. But the only thing I can think of after all the courts put on the record and gone through on all these pleas is the next thing I know. If I were you, if I were sitting in your shoes as I did for 20 years, although I was an elected criminal district attorney, so I hired assistants like Mr. Roberson to do these pleas. But I'm thinking if I'm you at this point this morning with 3 more to go dealing with the court, that I would probably request a 3rd chair be hired. That's what I would do if I were you. And I would tell the 3rd chair's job is to sit through this with the judge, who takes twice as much time as he needs to, and you have to be really patient. But it's up to Mr. Putnam. It's up to Mr. Putnam. Don't blame me, because that's on the record.
I won't, Your Honor. And I do know, though, that they operated up here under you and under another district attorney for 20 years with only 2 people per court. And so the second chair often spent all day in court. And I serve at the pleasure of the elected district attorney. And if this is what I need to do, this is what I get to do.
That's what I call excellent deduction from the facts. And so as I used to tell my assistants, one of them was Mr. Roberson, of course, if I've said twice, this is a decision you don't have to make. Don't worry about it. I'll let you know what I decide. So that's right. Mr. Putnam, needless to say, I was just thinking this is probably one of these mornings that we have where you're thinking, man, 3rd chair sure be nice. I know where the 3rd chair would be this morning. So that having been said, which really has nothing to do with anything, just to try to alleviate a little of repetitiveness the court that y'all have to sit through. This is on cause number 241-1232-21, State versus Jordan Jones, present before the court by Zoom from jail on a 3rd-degree felony, unlawful possession of a firearm by a felon. He's present. His attorney, Mr. Roberson's present. Ms. Anderson's present for the state. All right, you want to waive the reading, presentation of the indictment, all the other formalities, Mr. Roberson?
Judge, to waive the form reading the indictment, his name correctly set forth in the indictment, knows the range of punishment. What he's charged with, going to change his plea from not guilty to guilty.
All right, raise your right hand, Mr. Jones. I have to swear you in. Do you solemnly swear the testimony you'll give in the cause now on trial will be the truth, the whole truth, nothing but the truth, so help you God?
Yeah.
All right, Mr. Jones, if you can see the screen there, I've got some plea documents. They're all signed by a signature. I believe I can read, signed Jordan Jones. Is that your signature on the line above where it says defendant on all these plea papers? You probably can't see the screen right now. All that's up on the screen is the indictment. So let me ask a relevant question. Do you understand all the allegations and the charge in the indictment against you for unlawful possession of a firearm by a felon?
Yes.
Do you understand that's a 3rd-degree felony, carries a sentencing range of not less than 2 and more than 10 years in the Texas Department of Corrections Institutional Division, fine may be assessed of up to $10,000?
Yes.
All right. Have you been over all these plea papers with Mr. Roberson, your attorney?
Yes, sir.
There's a signature on all these plea documents, appears to the court. They're all signed Jordan Jones. Is that going to be your signature?
Yeah.
Some of these plea documents indicate you not only signed the document, but do you understand under the oath you just took, you've also sworn that all the documents are correct? Do you understand that?
Yes.
All right, I'm going to go through now and identify all your plea documents. You have a plea agreement with Ms. Anderson, you and Mr. Roberson. If you plead guilty to this 3rd-degree felony, you have a plea agreement for 3 years in the Texas Department of Corrections Institutional Division. That would be assessed with credit for time served from April the 13th, 2021 to the present. Also, pursuant to Article 1245, the court would consider on the pleas cause number 21-0275-2, a misdemeanor possession of controlled substance, cause number 2102-755, misdemeanor possession, class B. So both those would be considered by the court, which means Ms. Anderson will dismiss both these misdemeanors. So your plea, if you plead guilty, I'll assess 3 years in TDC with credit, and the state will dismiss both those misdemeanors. Is that your plea agreement?
Yes.
All right. In addition to the plea agreement, I've got the following plea papers. An acknowledgement of admonishments or explanations. There's 7 of them. You and Mr. Roberson have signed below the 7th one. Do you understand all 7 explanations?
Yes.
Next document, your waiver of trial by jury, where you tell me you understand you have a right to a jury trial. Then you say knowing that you knowingly and intentionally waive, meaning give up your right to a jury trial and just ask the court to hear the case on your plea of guilty without a jury. Is that correct?
Yes.
Then there's a signed and sworn to waiver of confrontation with witnesses. There's a stipulation of evidence, which is the next document signed now sworn to by you also. Do you understand that stipulation of evidence states too, that's a written judicial confession under oath by you to all the allegations on the charge and the indictment. Do you understand that?
Yes.
Did you sign and swear to the stipulation of evidence freely, intelligently, knowingly, and voluntarily?
Yes.
All right, court approves and admits into evidence, statement exhibit number 2, signed, sworn to stipulation of evidence. There's an agreement to stipulate testimony. There's a form you signed with Mr. Roberson, waiving, giving up your right to appeal, waiving and giving up your right to file a motion for new trial. You've requested a waiver on this case of the police sentence. Understanding all the allegations, the charge and the indictment, all your plea papers, your waiver of your right to trial by jury. Do you understand everything?
Yes, sir.
All right. The court has to go through now and ask you some questions. Court is asking these questions for purposes of your plea and this cause number. If the court asks you any question you don't understand, be sure and tell me. These questions are pretty straightforward. All right, these are for purposes of cause number 241-1232-21, State versus Jordan Jones, unlawful possession of firearm by a felon, 3rd-degree felony is alleged in the indictment. Do you read, write, and understand English?
Yes.
Have you consumed any alcohol in the last 24 hours?
No.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or
No,
heavy
sir.
substances in your system?
No, sir.
All right. Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything you're doing in court today by Zoom about the facts of the case and all your plea papers with your attorney, Mr. Roberson?
Yes.
The competent Mr. Roberson?
Yes, Your Honor.
Any evidence of incompetence, Ms. Anderson?
No, sir.
All right, court notes State's counsel signed her consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed sworn to by the defendant, signed by his attorney. All right, just to sort of recap it, Mr. Jones, you do understand all the allegations and the charge in the indictment against you, is that correct?
Yes.
And you do understand the full range of sentencing for the offense charged in the indictment, as well as all the plea papers you've signed or signed and sworn to, is that correct?
Yes.
Do you have any questions for me?
No, I just have one question for my attorney.
Go ahead. Mr. Roberson's on the screen. As long as this isn't something, I mean, obviously, I'm going to be listing, State's attorney is going to be listing. If you understand that, you can ask Mr. Roberson a question if you want.
I was just wondering about, you did talk to Natalie, didn't you, over Natalie Anderson?
I've been in conversation with his attorney over in Gregg County. She understands what's going on. I will contact her as soon as we're finished.
And she said yes on that?
Yes, everything's okay. Yes.
Okay.
All right. In cause number 241-1232-21, Mr. Jones, what is your plea today to the indictment charging you with unlawful possession of a firearm by a felon, 3rd-degree felony is alleged in the indictment?
Guilty.
I'm sorry?
Say guilty.
All right. Are you entering your plea of guilty to the indictment today because you are guilty of the offense and for no other reason?
Yes.
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
No.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily, because you committed the offense charged against you in the indictment.
Yes.
And you're not pleading guilty because of any type of unrealistic hope of pardon, parole, or leniency. Is that correct?
No.
All right, the court does receive and accept your plea of guilty. What do you have, Ms. Anderson?
Your Honor, we offer states 1, the plea packet with signed waivers and admonishments. States 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
No objection. The court admits into evidence states 1, all the plea papers. States 2, the signed and sworn to stipulation of evidence, the written judicial confession. States 3, it's proved by the court admitted into evidence, discovery compliance. The court in the case then having admitted into evidence with no objection, state exhibits 1, 2, and 3, finding all those exhibits were done freely, intelligently, knowingly, and voluntarily by the defendant. Further, the court does find the defendant's plea of guilty to the indictment, charging him with unlawful possession of a firearm by a felon, a third-degree felony. Court finds the defendant's plea of guilty to this indictment was entered freely, intelligently, knowingly, and voluntarily. The court receives and accepts the plea of guilty. Court does find the defendant guilty of the offense of unlawful possession of a firearm by a felon, a third-degree felony, as alleged in the indictment. The court follows also the plea agreement and the recommendation of the state assessing the sentence at 3 years of the Texas Department of Corrections Institutional Division. That's assessed with credit for time served, according to Mr. Robertson, from April the 13th, 2021 to the present. Also, pursuant to Article 1245, the court has considered a cause number 2102-752 for, I've considered it, it's a misdemeanor charge, can't quite pick it up in the writing. Also, I've considered a possession of marijuana, Class B, 2102-755, so the state's going to dismiss both those. Any legal reason for formal sentencing?
No legal reason, Your Honor.
Court in the case then, based upon the defendant's plea of guilty to the offense of unlawful possession of a firearm by a felon, a third-degree felony is alleged in the indictment. The evidence presented and admitted into the record by the court. The court does find the defendant guilty of the offense of unlawful possession of a firearm by a felon, third-degree felony is alleged in the indictment. Follows the plea agreement, the recommendation of the state. Assesses the sentence at 3 years in the Texas Department of Corrections Institutional Division. That's assessed with credit for time served. Waiver of appeal, giving up his right to appeal, waiver of right to file a motion to new trial, approved by the court. The court has considered those 2 misdemeanors as set forth in the plea agreement pursuant to Article 1245, so they'll be dismissed by the state. You understand, Mr. Jones, you have filed with the court a waiver giving up your right to appeal and waiving and giving up your right to file a motion for new trial. You understand that?
Yes, sir.
All right, it's the order of the court, defendant Mr. Jones be continued in the custody of the sheriff until he can be transported to the Texas Department of Corrections Institutional Division to serve the 3-year sentence assessed by the court with credit for time served. Are you satisfied with the legal representation of your court-appointed attorney, Mr. Robertson, Mr. Jones?
Mr. Robertson?
Yeah.
Yeah. In other words, are you satisfied with Mr. Robertson's legal representation?
Yeah, I was going to ask him a question real quick.
Okay, I'll get with you after this. We got other hearings.
All right. Yeah.
Okay. You have anything else, Ms. Anderson?
No, sir.
We're in recess. Defendant's continued in custody and be transported to TDC to serve the 3 years with credit.
Mr. Jones, hold on. We'll see who the next person is.
We need Cody McCoy.
Mr. McCoy?
I'll be right back.
Tabitha, are you there?
Yes, ma'am, I'm here.
Oh, just checking on, so we've still got McCoy, Perry, and Walker. And then what about Alvarez?
He's here in my office.
Oh, he's there. Okay. Thank you. Wasn't sure.
That's from there. And all this stuff. What's that saying?
It'll be just a minute, Cody. Just the court took a break about 2 or 3 minutes.
All right. Well, while they're at break, Mr. Robertson, I got a question. Is there any way we can do a 1244A?
No, this is what they're gonna do.
Okay.
Is Christie on back? She on back? All right, we're back on the record. Can everyone hear the court?
Yes, sir.
Present, Your Honor.
Yeah, are you there, Mr. Roberson?
I'm present.
You there, Ms. Anderson?
Yes, sir.
The only other matter I can put on the record, which has nothing to do with anything, Ms. Anderson, is an explanation for you and Mr. Roberson. I came straight out of the dentist chair down here this morning. So that's my only other explanation. I think that has a lot to do with it. All that and the fact that what number plea are we on?
Judge, I think we got 3 more pleas, and I can inform the court we had more, but they were in quarantine.
Yes, sir.
Well, how many have we done?
About, what, 4?
We've done 4 so far.
Okay. How many do we have left?
3.
We still have 3.
Well, I'd just like to compliment, now this isn't on the record, but I'd just like to compliment, well, I will put it on the record. I'd just like to compliment Mr. Roberson and Ms. Anderson for working out this many cases and getting them set for pleas today before the court. I think both state and defense have done a real good job on working with each other and getting these, because every case I've seen certainly looks like it should be a plea, even though I don't know anything about the facts. Anything else? I think y'all are doing a good job. I think according to Mr. Chambliss, who I just conferred with outside there, I think we've got 3 left, something like that. I'm not sure. All right, the next one, now that I'm getting to it, cause number 241-1448-21, State versus Cody McCoy, State Jail felony burglary of a building. He is present by Zoom. Raise your right hand, Mr. McCoy, so I can get you sworn in. Solemnly swear your testimony be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Judge,
All right,
you
also
should
present, of
have
course,
2
Ms.
cases.
Anderson's, I'm sorry.
You should have 2 cases on
Two
Cody
bur-
McCoy. There's 2.
Both are burglary of building.
Okay, hang on. That's correct. So I'll call the first one, 241-1448-21, burglary of a building. The other cause number is also State Jail felony 241-0087-21 for burglary of a building. Here I have 2 indictments for burglary of a building. Going to be taking both pleas at the same time. Let's see here. All right, to Mr. McCoy, have you been over the indictments in both? There's 2 different cases, 008721 and 1448-21. They both charge the same offense, burglary of a building. Have you been over all the allegations and the charge in each indictment with Mr. Roberson, as well as all your plea documents in both these cases with Mr. Roberson?
Yes, sir.
And you understand the
Judge,
state's
you might-
recommending in each case, which you and Mr. Roberson have accepted. Plea agreement is, if you plead guilty, I'll assess the sentence at 12 months in a state jail facility in each cause number. Those 12-month sentences will run concurrent or at the same time. Also, as indicated on the plea documents, the 12-month sentence I'll assess at each cause number for the offense of burglary of a building, they'll be ordered pursuant to the plea to run concurrent at the same time as a parole violation and a sentence assessed in, well, each sentence will run concurrent or at the same time, and each sentence will run concurrent with the time you receive for a parole violation, whatever that is. Is that the basic plea, Ms. Anderson?
It is, Your Honor. We're doing 12 months concurrent, and these should run concurrent with any other cases that he has.
Is that it, Mr. Roberson?
That's correct, Your Honor. And also, Judge, I think you need to swear Mr. McCoy in.
Yes, sir.
I'm sorry, what was that, Mr. Roberson?
You need to swear Mr. McCoy in, Your Honor.
Oh, yes, I'm going to do that. I was trying to get through and get a little groundwork laid there. Raise your right hand, Mr. McCoy. You solemnly swear the testimony you'll give in the cause is now on trial will be the truth, the whole truth, nothing but the truth to help you God?
Yes, sir.
All right, Mr. McCoy, we have two cause numbers. Cause number 241-1448-21, charges burglary of a building, state jail felony is alleged in the indictment. Cause number 241-0087-21, charges burglary of a building, state jail felony is alleged in the indictment. We're doing both these pleas at the same time. All the questions the court asks are going to be for your pleas and each cause number. Do you understand that?
Yes, sir.
You understand, of course, the state's recommendation, which I'm going to follow in each case, is 12 months in a state jail facility. Those 12-month sentences with credit in the state jail facility will each be ordered to run concurrent with the other one. So both 12-month sentences with credit for time served in the state jail facility will run concurrent. Do you understand that?
Yes, sir.
All right, now I've got to go through and identify your plea documents. I'm going to identify the plea documents one time because I have the same plea documents in both cause numbers. Just starting with 241-1448-21, I've got these are all signed by you and your attorney, Mr. Roberson. Some are signed and sworn to by you. They're all signed by Ms. Anderson. I've got your first 241-1448-21, same plea agreement as you got over in the other one. If you enter a plea of guilty to this cause number 241-1448, charging burglary of a building, and if you plead guilty over in cause number 241-0087-21 to burglary of a building, I'm going to follow the plea agreements, assess 12 months in a state jail facility. Sentences will be ordered to run concurrent or at the same time with credit for time served in each case. Is that the plea? Those the plea agreements?
That's correct, Your Honor.
Is that correct, Ms. Anderson?
It is, Your Honor.
Okay. Are those your plea agreements, Mr. McCoy?
Yes, sir.
All right. Here are the other plea documents. I have these plea documents in both cases, all signed and sworn to by you. That is your signature, Cody McCoy, on the screen, isn't it?
Yes, sir.
All right. So we've got the plea agreements I've been over. There's an acknowledgement of admonishments. Gives you the full range of sentencing, 180 days up to 2 years in a state jail facility. Fine may be assessed of up to $10,000. There's 7 admonishments. You and Mr. Roberson have signed right below the 7th one. You understand in the next document, waiver of trial by jury, you've waived giving up your right to a jury trial on both these indictments for burglary of a building. You understand that?
Yes, sir.
Also, you've waived confrontation with witnesses and agreed to stipulate testimony. You understand that?
Yes, sir.
Your stipulation of evidence in each case is signed and now sworn to by you. Stipulation of evidence is stage 2. When you sign and swore to stage 2, the stipulation of evidence, had you been over that document along with all the others with Mr. Robeson, so you understood the content of your stipulations of evidence? In other words, do you understand the stipulations of evidence signed and now sworn to by you are written judicial confessions under oath by you to all the allegations and the charge in each indictment?
Yes, sir.
Did you sign and swear to each one of those stipulations of evidence freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, then again, in both cases, agreements to stipulate testimony, in both cases, waivers of appeal, giving up your right to appeal, waiving, giving up your right to file a motion for new trial. Waiver of the pre-sentences has been approved. The last document in each case will be a trial court certification of your rights to appeal. They're signed by you and Mr. Robeson. I'll check each one of them where it shows this is a plea bargain case and you have no right to appeal. I'll also check where it shows in each case you've waived your right to appeal. Do you understand all that?
Yes, sir.
understanding all of the allegations and the charge in each indictment in 241-1448-21 and in 241-0087-21. Do you understand all the allegations, the charge in each indictment, and all of your plea documents?
Yes, sir.
All right, are you offering, you may already have, are you offering states 1, 2, and 3 into evidence, Ms. Anderson? You probably have in both cases.
I haven't, but I'll do so now, Your Honor.
No
With
objection.
no objection, states exhibits 1, 2, and 3 are all admitted into evidence in the record of each cause number. The court in each cause number in admitting into evidence states exhibits 1, 2, and 3, finding in each cause number that the defendant's waiver of his rights to execution of all the other documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. The court has in each one of the cause numbers for the record, has in each cause number the following documents. The court has indictments which charge the defendant with offense of burglary of the building, state jail felony. Court has the plea documents, which the court has indicated on the record, all signed or signed sworn to by the defendant in both cases. All right, be sure I've got this, Mr. McCoy, in both cases. Just for the record, you do read, write, and understand English, correct?
Yes, sir.
You have not consumed any alcohol in the last 24 hours, correct?
No, sir.
You are not under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system. Is that correct?
Yes, sir. That's correct.
You've never been confined in a mental institution or under psychiatric treatment. Is that correct?
Yes, sir.
Do you understand everything you're doing in court today on both cases?
Yes, sir.
Have you gone over everything about the facts of each case and everything you're doing in court today with your attorney, Mr. Roberson?
Yes, sir.
Is he competent, Mr. Roberson, for purposes of both pleas?
He is, Your Honor.
Any evidence of incompetence, Ms. Anderson?
No, sir.
Court notes state's counsel signed her consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers signed or sworn to by the defendant in each case. All right, now, Mr. McCoy, in each cause number, you've gone over the indictment, all your plea papers, and your plea agreements in both cases with Mr. Roberson, your attorney. Is that correct?
Yes, sir.
You understand everything we've been over?
Yes, sir.
You have any questions for me about anything?
No, sir.
In cause number 241-0087-21, what is your plea today to the indictment? In that cause number, charges you with a state jail felony, burglary of a building. Like, is your plea guilty or not guilty?
Guilty.
In cause number 241-1448-21, what is your plea today to the indictment? In that cause number, also charging burglary of a building.
Guilty.
Are you entering your pleas of guilty to the indictments in each cause number today because you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you in any way or promised you anything to plead guilty in either case?
No, sir.
Are you entering your pleas of guilty to the indictments in each cause number freely, intelligently, knowingly, and voluntarily because you committed the offense charged in each indictment?
Yes, sir.
Are you entering your pleas of guilty? You're not pleading guilty to either cause number or the indictment, either cause number, because you have any type of delusion in your mind or some type of unrealistic hope of pardon, parole, or leniency. Is that correct?
Yes, sir.
Okay. The court does receive and accept your pleas of guilty to the offense of burglary of a building, a state jail felony, and cause number 241-0087-21, and the court does admit into evidence all the plea documents in cause number 241-1448-21. Court does receive and accept the defendant's plea of guilty to the offense of burglary of a building alleged against by the state in each indictment. Finding the defendant's pleas of guilty to the indictment in each cause number is entered freely, intelligently, knowingly, and voluntarily. The court finding the defendant guilty of the offense of burglary of a building is alleged in each cause number moves to sentencing. Ms. Anderson.
Your Honor, in each cause, we have a copy of States 4, an electronic copy of the written discovery.
No objection, Your Honor.
Both scores admitted into evidence without objection. Court needs cause number then for purposes of sentencing. The court having found the defendant guilty of the offense of burglary of a building is alleged in the indictment in each cause number 0087-21 and 1448-21. The court does find the defendant guilty of the offense of burglary of a building and a state jail felony as alleged in the indictment in each case. Court follows the plea agreement in each case, assessing the sentence at 12 months in a state jail facility in each cause number for the offense charged in the indictment. Each 12-month sentence is assessed with credit for time served. Sentence is formally pronounced. The court finds the defendant guilty of the offense of burglary of a building, state jail felony as alleged in the indictment. Each cause number, the court following the plea agreement, assessing the sentence at 12 months in a state jail facility with credit for time served. For each cause number, each 12-month sentence and each cause number is ordered to run concurrent or at the same time with each other with credit for time served. Waivers of appeal, giving up right to appeal. Waivers of motion for new trial, giving up right to file motion for new trial received and accepted by the court. Sentence is formally pronounced 12 months in a state jail facility for the offense charged in each indictment. 12-month sentence is assessed with credit for time served, ordered to run concurrent with each other in each case. Mr. McCoy, you satisfied with your court-appointed attorney, Mr. Clifton Roberson, his representation?
Yes, sir.
All right. Anything further, Ms. Anderson?
No, sir.
Anything further, Mr. Roberson?
No, Your Honor.
All right. The defendant, Mr. McCoy, is continuing the custody of the sheriff. He can be transported to a state jail facility, serve the 12-month sentence assessed by the court, 12-month sentence. For each cause number, each 12-month sentence order to run concurrent with the other 12-month sentence for credit for time served. We're in recess on this case, counsel.
Will you let them know we need Calvin Walker? One out of jail and this one.
Is it in jail?
Yes.
All right, we're on the record in calls number 2410880-20, State versus Calvin Earl Walker, charged by an indictment, possession of a controlled substance less than a gram.
I don't think we have Mr. Walker yet.
You're right again, Ms. Anderson.
He's an important part of the process.
I was so absorbed with you and Mr. Robertson's plea papers, I forgot to look up.
Oh, I thought you were maybe absorbed with the tops of our heads because we were both doing paperwork and other stuff.
To tell you the honest truth, I was actually sort of considering what time I'd be leaving in the morning to go dove hunting in Coleman County.
Oh, there you go.
I'm supposed to come back on Sunday afternoon, but I'm reconsidering right now. Thinking about filing a motion for continuance and see if out at Red Top Lodge I can continue hunting on Monday. I doubt that my continuance will be granted by Nathan, the owner, unless I pay a certain amount of money for the extension. So, and probably I may have passed out from heat before Monday anyway, in those open dove fields about 5:30 in the afternoon. Yes. Everyone was really looking forward to going opening weekend. First time we've made it out there opening weekend, then it turned out to be 100 degrees. On the afternoon hunt, morning won't be bad, so just have to shoot in a hurry. I just hope there's some dove, because dove are pretty smart. We called out there to see if, with doves still coming in. Apparently they are. Some places it's so hot the dove aren't even coming in. I guess it diverted to another location or something, but it's supposed to be out there.
We'll see.
Go all the way through Cross Plains, Texas. Joe Price lion sale stands for sale for deer hunting, and that's a lot of deer hunting out there.
Right, thumbprint, we're gonna place one there, on this part, and right there.
I guess we're ready. Looks like the defendant on TV.
That's
We're on
Mr.
the record
Walker,
in-
Your Honor.
All right, we're on the record in 2410880-20 State versus Calvin Walker. Charged with offense, state jail, felony possession of a controlled substance less than a gram. Goodness gracious. Bond is set on the indictment. Oh, it's a bond violation. Alias Capius went out for a bond violation. That's the problem. $150,000 on the bond violation more. I see it now. All right. Raise your right hand, Mr. Walker. You solemnly swear the testimony you'll give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Walker, have you been over this indictment charging you with possession of controlled substance, cocaine, in the amount of less than a gram with your attorney, Mr. Clifton Roberson?
Yes, sir.
All right, got a set of plea documents here, Mr. Walker. The plea documents all are signed Calvin Walker. I can easily read the signature. Did you sign all these plea documents, Calvin Walker?
Yes, sir.
If the plea document indicates you signed it and then swore to it, is that correct?
Yes, sir.
Okay. Just to be sure, you got your right hand up. You've had it up for a while. Do you solemnly swear the testimony you'll give will be the truth, whole truth, nothing but the truth, and all the plea documents signed
Yes.
or sworn to by you are being sworn to by you under oath now, freely, intelligently, knowingly, and voluntarily. So help you God.
Yes, sir.
All right. You have your plea agreements, 9 months with credit for possession of a controlled substance, state jail felony. You understand that plea agreement, Mr. Walker?
Yes, sir. The time credit, the time credit, what is
Well,
that?
the time credit, the time credit, how long you been in the Smith County Jail, you figure?
4 months. Well,
Well, the time credit, when I assessed this sentence at 9 months in a state jail facility,
yeah. Yes.
following the plea agreement, I assessed the 9 months with credit for time served. What I'm talking about there is the time you served in the Smith County Jail will be time served by you on this 9-month sentence. So when you get down to the state jail, they'll know how much time you got left.
Okay, because I caught this case last year, and then I was back in here in December to January. I just didn't see it on my credit road thing. I was just asking so that.
I show he already has a, I'm sorry, Your Honor.
Go ahead, Ms. Anderson. What's he talking about?
As of today, I show that Mr. Walker has, let me just make sure. I show that he has 85, about 130 days of credit, 129 days of credit as of today.
All right, that credit, that
includes last year too.
9 months. I'm sorry, Ms. Anderson.
I'm sorry, that includes another 15 days from December 29th to January 12th. That's not on the plea paperwork, but he will get credit for that time also. I think that's what he's concerned about.
I'm sure it is. Do you understand that now, Mr.?
Yes, sir. Yes, sir. Okay. Yes, sir. Yes, sir.
So your plea agreement, if you plead guilty, the court's going to assess 9 months. It's assessed with credit for time served. It's actually written on the plea papers, according to Mr. Roberson. It's from March the 18th, 2021 to April the 30th, 2021, then from June the 24th, 2021 to the present. So that's the credit for time served Ms. Anderson's figured up. Is that your plea agreement, 9 months with credit for time served?
Yes, sir.
All right, then I've got an acknowledgement of admonishments. These are all signed by you, Calvin Walker. Actually, signature I can easily read, as opposed to mine. And then Mr. Roberson signed all of them. There's 5 admonishments for explanations. Do you understand those? You signed right below the 5th one.
Yes, sir.
Okay. Do you understand you're waiving giving up your right to a trial by jury?
Yes, sir.
You understand you're waiving confrontation with witnesses, like there are no witnesses here for Mr. Roberson to cross-examine, and you're agreeing to stipulate testimony. Do you understand that?
Yes, sir.
Then you signed and sworn to now a stipulation of evidence stage 2. That's a written judicial confession under oath. to the charge in the indictment. Do you understand that?
Yes, sir.
Then you signed an agreement to stipulate testimony on the plea. These are all signed by Mr. Roberson also. You signed a waiver. Waiver means to give up, waiving and giving up your right to file a motion for new trial and waiving and giving up your right to appeal. Do you understand that, Mr. Walker?
Yes, sir, Your Honor.
All right. The only other documents I've got here before me in your case, I've already waived the pre-sentence. Then there's a trial court certification of your rights to appeal. That's signed by you and Mr. Roberson already. It'll be signed by the judge, but the court will check where it shows this is a plea bargain case and you have no right of appeal, and also check where it says you have waived your right of appeal. Do you understand that, Mr. Walker?
Yes, sir, Your Honor.
All right, Mr. Walker, the only other documents I've got is advice you've received from Mr. Roberson on your rights to appeal. So understanding all of these plea documents, your plea agreement for 9 months in a state jail with credit for time served, I've already indicated what that is on the front of the plea documents. Understanding all the allegations and the charge in the indictment for possession of a controlled substance, a state jail felony, less than a gram. Do you still wish to go forward on your plea of guilty without a jury?
Yes, sir, Your Honor.
All right, Mr. Walker, what do you read, write, and understand English?
Yes, sir, Your Honor.
Have you consumed, drank any alcohol in the last 24 hours?
No, sir, Your Honor.
All right. Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir, Your Honor.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir, Your Honor.
Do you understand everything you're doing in court, Mr. Walker?
Yes, sir, Your Honor.
Have you gone over all the facts of your case and everything about your case, including all these plea documents you signed with your attorney, Mr. Roberson?
Yes, I did, Your Honor.
Is he competent, Mr. Roberson?
He is, Your Honor.
Any evidence of incompetence, Ms. Anderson?
None, Your Honor.
All right. The court in this case, finding that Mr. Walker understands all the allegations, the charge in his indictment, all his plea papers, and the full range of sentencing. The court in this case, in regard on cause number 2410880-20. Now, what is your plea today on this indictment to possession of a controlled substance, Mr. Walker?
Guilty, Your Honor.
All right. Are you pleading guilty freely, intelligently, knowingly, and voluntarily because you committed the offense?
Yes, sir, Your Honor.
Has anyone threatened you in any way or promised you anything or made you plead guilty?
No, sir, Your Honor.
Are you in your plea of guilty to this indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, sir, Your Honor.
Are you in your plea of guilty to the indictment today because you have any type of delusion in your mind?
No, sir, Your Honor.
All right, the court does receive and accept your plea of guilty to the state jail felony offense of possession of a controlled substance as alleged in the indictment. All the documents, all the state's exhibits. Well, you want to offer whatever you got for sentencing, Ms. Anderson?
Your Honor, we'd offer states 1, 2, and 3 for purposes of guilt innocence with the plea packet. And then we'd also offer a copy of states 4, an electronic copy of the written discovery in this case.
No objection, Your Honor.
Well, with no objection, states exhibits 1, 2, 3, and 4 admitted into evidence without objection. The court in this case, based upon Mr. Walker's plea of guilty to the offense of possession of a controlled substance less than a gram, which the court finds was entered freely, intelligently, knowingly, and voluntarily. The court does find the defendant guilty of the offense of possession of a controlled substance less than a gram as alleged in the indictment. Follows the plea agreement to recommendation of the state to assess the sentence at 9 months in a state jail facility. That 9-month sentence is assessed with credit for time served from March 18, 2021 to April the 30th, 2021. And from June the 24th, 2021 to the present time. Also, as part of the sentence, Mr. Walker's ordered to pay $180 lab fee to DPS. Mr. Walker, you understand you filed a document with the court that waives and gives up your right to appeal. Do you understand that?
Yes, sir, Your Honor.
All right, Mr. Walker, are you waiving your right to appeal freely, intelligently, knowingly, and voluntarily?
Yes, sir, Your Honor.
Court receives and accepts your waiver of appeal, Mr. Walker. Mr. Roberson's been your court-appointed attorney. Are you satisfied with the legal representation of your court-appointed attorney, Mr. Roberson?
I definitely am, Your Honor.
All right, Mr. Walker. Mr. Walker, the record should reflect, I'm formally pronouncing sentence, finding you guilty of the offense of this state jail felony possession of controlled substance, assessing your sentence 9 months in a state jail facility, assessed with credit for time served, restitutions over the DPS and $140 for the analysis of the controlled substance. Mr. Walker, before we go off the screen, I have, since I went on the bench, made that decision after I was criminal district attorney for about 20 years. I believe if you're not the most, you're one of the most polite defendants that's ever been before this court. I'll tell you that.
Thank you, Judge.
I really appreciate the manner in which you've answered the questions and how you've handled yourself on this plea. If other defendants conducted themselves as you have, the court, along with Ms. Anderson and Mr. Robertson, will all have an easier job.
Yes.
So good luck to you, Mr. Walker.
Well, thank you very much. The Lord is good. I appreciate all y'all assistance.
He's been working with you, Mr. Walker. Thank you.
Yeah, so I appreciate it. That's my Vietnam blessing from the service right there.
Good luck, Mr. Walker.
Thank you, Mr. Robertson and Mr. Y'all. Appreciate it.
Thank you, Mr. Walker. Good luck.
Oh, yes, sir. Y'all done the trick. I appreciate it.
Tell you the honest truth, I'm gonna have my court reporter who's somewhere in the 241st transcribe this whole plea. I won't see another one before I'm through in the next year and a half. All right, I've just been handed a docket sheet. It's blank. It says cause number 2410931-21, State versus Tridarian Perry, charged with aggravated assault with a deadly weapon, second-degree felony. I don't see him on screen yet. What's up?
We're waiting on him.
Okay, we're waiting on him. Is this the last one, Tap?
We have one out of jail.
Okay, we're doing it by Zoom.
Yes, sir.
Okay.
He's in my office, Your Honor. And as I told you a few minutes ago, Judge, we had other pleas worked out, probably about 4 or 5 other pleas, but they in quarantine, so we couldn't do those.
So, okay, I'm with you on that.
Well, and I just want to point out too, it's not just that we had the pleas worked out, it's that Mr. Roberson had all his paperwork done and to the court before 5 p.m. yesterday, and I was able to sign off on everything this morning. So Mr. Roberson did a good job, not only of just getting it ready, but getting it all to the court ahead of time. That makes such a difference. Thank you, Clifton.
You're welcome. You're welcome.
So now, Ms. Anderson, that
Yes, sir.
doesn't surprise me how Mr. Roberson handled it, to say the least. Are we going ahead and taking Mr. Tridarian Perry's plea?
I don't believe that we have an agreement yet on Mr. Perry.
Okay. It's on an indictment charging aggravated assault with a deadly weapon.
I think the defense just has some kind of announcement it needs to make. And then, yes, there's still another guy that's in Mr. Roberson's office after that has a probation plea.
Okay, so what's, just for the record, on cause number 2410931-21, we don't have the defendant. We're not going forward on that. The defendant is.
I think they're waiting to call him at the jail. If I'm not mistaken, we're waiting for him to be on screen. Is that right,
Okay.
Tabitha?
That is correct.
Looks like his bond set at $300,000, so that's fine. I'm with you now.
And Judge, I confirm the court, there's a plea agreement. We just got to get on the record if he wants to accept the plea agreement or not.
There appears to be one where perhaps your consultations have come to an end. Been down this road before, Mr. Roberson, will you? And I know you thoroughly consult with the defendants, but sometimes once you know for sure they're not going to accept the plea, you don't just keep bringing it up.
That
They
is
can
true.
always contact you, as I'm sure many have, and tell you they've changed their minds, but are we, in regard to, there is no plea on Perry, is that correct?
Judge, there was an offer, Mr. Chandler said 20 years, but he said, however, Clifton, if he'll sign for 15, we will take 15.
So that's what we need to cover when he appears on screen?
Yes, Your
Yes,
Honor.
sir.
All right.
Oh, there he is.
All right, we're on the record by Zoom and cause number 241-0931-21, State versus Tridarian Perry, charged by an indictment with a second-degree felony aggravated assault with deadly weapon. There's an allegation in the last paragraph the defendant has a prior felony conviction for the offense of tampering or fabricating physical evidence up in Hopkins County in the 8th District Court. If that was proven, the second-degree felony, which carries a sentencing range of 2 to 20, would then be enhanced to a first-degree felony. So the sentencing range, if the defendant pleads true to that last paragraph to the prior felony, would become not less than 5 no more than 99 years of life. Texas Department of Corrections Institutional Division. So defendant, Mr. Perry, is on the screen now by Zoom. Go ahead, Ms. Anderson. Mr. Roberson's on screen. Go ahead.
Your Honor, the current plea offer from the state was 20 years confinement in the institutional division. Mr. Chamness had indicated he would be willing to possibly take 15 if the defendant were to sign for that. I think we're here today to find out whether or not Mr. Perry accepts or rejects this offer.
Okay, you have questions you want to ask him, Mr. Roberson?
No, Your Honor, that is where we are, Judge. I informed my client that the least they will go would be 15 years. He's to inform the court today if he rejects the plea offer or if he wants to accept the plea offer.
All right, Mr. Perry, I'm getting ready to ask you that question. I just said this once, but I want to be sure you understand it. The indictment charges aggravated assault with a deadly weapon. That carries a full sentencing range of not less than 2 no more than 20 years in the Texas Department of Corrections Institutional Division. Fine may be assessed at up to $10,000. However, this indictment in the last paragraph alleges that prior to the commission of the charged offense, the aggravated assault with a deadly weapon, it alleges that on the 9th day of October 2015, in cause number 1524902 in the 8th District Court of Hopkins County, Texas, it's alleged that you were finally convicted of the felony offense of tampering or fabricating physical evidence. If allegations in the last paragraph alleging a prior felony conviction were proven, then your sentencing range would be enhanced or increased. It would no longer be a second degree. It would be enhanced to a first degree. So your full range of sentencing would become, if the allegations of the prior felony are proved, your sentencing range would become not less than 5 years, nor more than 99 years of life in the Texas Department of Corrections. Fine may be assessed at up to $10,000. So I believe that Ms. Anderson, who represents, she's obviously Assistant District Attorney representing the state. She has told the court that the state's offer today is 15 years. If you plead guilty, the state's willing to recommend 15 years in the Texas Department of Corrections Institutional Division with credit for time served. Mr. Roberson, correct?
That is correct, Your Honor.
Is that correct, Ms. Anderson?
Yes, Your Honor.
All right, so we appear to be here today, Mr. Perry, with you on Zoom screen, so the court can find out whether or not you wish to accept the state's offer, which was what, Ms. Anderson?
If he were to sign right away, it would be as low as 15. The original offer was 20.
All right, so if you accept the 15, the state's offer today is 15 years in the Texas Department of Corrections Institutional Division. If the prior is proven, that would be on they're willing to offer 15 years today with credit. That's the bottom line. So what we're here today to find out is, because this indictment can be enhanced up to a first degree. Right now it stands as a second degree, 2 to 20, and their offer's 15. I just want you to be understand that if they prove that prior up in Hopkins County, it'll make your full range of sentencing up to a first degree felony. It'll go to a first degree, not less than 5 no more than 99 years of life in a penitentiary. So what we're trying to figure out here today, Mr. Perry, with Mr. Roberson on the screen, is whether or not you want to accept the state's offer of 15 years in TDC. That'd be assessed with credit for time served. The court would make an affirmative finding because if you plead guilty, there would be a stipulation of evidence to the second paragraph, which alleges you used or exhibit a deadly weapon, a firearm. Then the manner and means of its use and intended use is capable of causing death and serious bodily injury during the commission of or immediate flight from the offense. Whether you stipulate and plead to that in a plea agreement for 15 years, or whether or not you reject the state's plea offer and proceed to trial, then if the jury finds you guilty of the offense charged in the indictment, and then the state proves those allegations not only of the prior felony, but that you used or exhibited a deadly weapon with a firearm, whatever sentence would be assessed by the jury would have that affirmative finding the court would make. That triggers halftime. Okay, so I guess what we're trying to figure out, and I just want to explain all of it if I could to you, Mr. Perry. Why don't you go ahead and ask him the questions you need to ask, Mr. Rose?
Mr. Perry, you heard the plea recommendation by the state for 15 years. They're not going to go any lower. At this time, do you want to accept the 15 years or do you want a jury trial?
Mr. Your Honor, sir, I really like to ask if I could get more time to hire an attorney.
Mr. Robertson is your court-appointed attorney. The best way I can answer that question is that if there's not a plea agreement on the case today, the case will go on to the court's trial docket. And I don't know when the court would reach the case, but that's the bottom line they're trying to figure out today is whether or not you want to accept or reject the plea. You always have the right to hire your own attorney. Mr. Robertson's been appointed because you had signed an affidavit saying you did not have the means. You were too poor to hire an attorney. That triggered the appointment of Mr. Robertson because that affidavit indicated you were indigent, unable to hire an attorney.
Yes, sir.
And Judge, he can hire an attorney. We just need to know if he accepted and rejected a plea. If he rejects a plea, like you said, it'd be put on a trial docket. And in the meantime, he can hire an attorney, Your Honor.
And Your Honor, I just want to make it clear too, a new attorney, there's not going to be a better plea offer. This, Mr. Roberson has negotiated the best plea offer that's going to be available for Mr. Perry.
So if the court understands it, then Ms. Anderson, if Mr. Perry rejects the plea offer today, and then today elects to go to a jury trial, the state's offer is never going to be higher and may not be the same as the 15 years today. Is that correct?
Yes, sir.
With an affirmative finding of a deadly weapon. So it looks like we're here to find out what you want to do, Mr. Perry. The answer, you can always hire your own attorney. I mean, you can hire your own attorney. If you hire your own attorney and that attorney appears before the court with you and states to the court he or she's been hired as your attorney, then Mr. Robertson would withdraw. The court would not ever appoint you another attorney in the case unless your hired attorney had some good reason to withdraw. Let's say if you didn't pay him or her. So we're just trying to find out what you want to
do. No, sir, I'm not willing to sign for 15.
Okay. The plea offer of 15 years with credit for time served rejected by the defendant. This plea offer will not again be accepted by the court, Ms. Anderson. So you and Mr. Chamness need to be ready to try the case. Right now, of course, Mr. Roberson's continued as the defendant's attorney. It'll go on the trial docket. The defendant is continued in custody on the current bond, which is on the back of the indictment in the case. Current bond is $300,000. The $300,000 surety bond is continued with conditions on the indictment. Anything else, Ms. Anderson?
No, sir.
Anything else, Mr. Roberson?
No, Your Honor.
All right, we're in recess. Defendants continued in custody. Case will be set on the next available jury trial docket. We're in recess.
Thank you, Your Honor.
Thank you.
Judge, we're ready on the next case whenever the court is ready.
All right, let me get the phone.
I'll take a look.
I can't. I'm still on Zoom. I'm sorry, you're gonna. I'm sorry, Your Honor.
Sorry. All right, we're on the record by Zoom. Again, this time calls number 2410973-21. State versus Marco Alvarez, present on Zoom with his attorney, Mr. Clifton Robertson. On indictment, charge of possession of controlled substance less than a gram. Ms. Anderson is present on Zoom. Representing the state, court's probation officer, Marcel, is present by Zoom. Just raise your right hand, Mr. Alvarez, but to get the plea done. Solemnly swear the testimony you'll give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Alvarez, I have a set of plea documents here. All the plea documents are signed, and we'll see if I can get your agreed punishment recommendation up on the screen so I can be sure the signature is yours. That's the plea agreement right there. Is that your signature where it's signed Marco Alvarez?
Yeah.
All right, did you go over all these plea documents with Mr. Robertson before you signed the documents? And you understand I just swore you to the documents?
Yes, sir.
All right. Your plea agreement is to enter a plea of guilty. Ms. Anderson's recommending your sentence of 5 years deferred adjudicated probation. That would be, you'd also be ordered as one of your 70 or so terms and conditions of your deferred probation. You'd be ordered to pay $180 to the lab fee for the lab fee at DPS. Is that it, Ms. Anderson?
It is, Your Honor.
Is that it, Mr. Robertson?
That's correct, Your Honor.
Is this your plea agreement, Mr. Alvarez?
Yes, Your Honor.
All right. In addition to the 5 deferred with a lab fee, $180 will be paid to DPS as a condition. The court has an acknowledgement of admonishments against Mr. Alvarez, full range of sentencing, not less than 180 days and more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. There's a total of 7 admonishments, or just explanations. There's 7 of them. Mr. Alvarez, on your plea, you signed below the 7th one, along with Mr. Robertson. Do you understand all the admonishments?
Yes, sir.
Next document's a waiver of trial by jury. It does what it says. It waives and it tells the court you are waiving, giving up your right to a trial by jury and asking the court to hear the case on your plea of guilty without a jury. Is that correct?
Yes, Your Honor.
Then there's a signed and sworn to waiver of confrontation with witnesses. There's a signed and sworn to stipulation of evidence, states 2. You understand, Mr. Alvarez, that signed and sworn to stipulation of evidence, stage 2, that's a written judicial confession or admission to the offense charged in the indictment under oath by you. Do you understand that?
Yes, Your Honor.
The court then has an agreement to stipulate testimony, a form for a waiver of appeal, a waiver of right to file a motion for new trial, waiver of the pre-sentence has already been approved. All right, do you understand all the allegations of charge in the indictment for possession of a controlled substance, the full range of sentencing, as well as all your plea documents?
Yes, Your Honor.
All right, I have to ask you some questions. They're pretty straightforward. Do you read, write, and understand English?
Yeah.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance,
No, sir.
intoxicant, or have any of those substances in your system?
No, sir.
All right. Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
All right. Do you understand everything you're doing in court today?
Yes, sir.
Have you been over all the facts of the case and all these plea documents you've signed or signed and sworn to with your attorney, Mr. Clifton Robertson?
Yes, sir.
Is he competent, Mr. Robertson?
Yes, Your Honor.
Any evidence of incompetence, Ms. Anderson?
No, Your Honor.
All right, court notes State's counsel signed her consent, approves the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers signed or signed sworn to by the defendant, signed by his attorney. You do understand all these plea documents you've signed or signed and sworn to? Is that correct, Mr. Alvarez?
Yes, Your Honor.
You have any questions for me about anything?
I wanted to ask you something.
You have
Sorry.
any questions?
Sorry.
All right. Okay, and calls number 2.
If I got some questions, you said?
Yes, all I was asking, do you have any questions for the court?
No, because my lawyer explained me everything before I signed.
That's actually how it's supposed to work. Would you believe me if I told you it doesn't always work like that? That's why I'm asking you. At any rate, in cause number 241-0973-21, what is your plea today to the indictment charging you with possession of a controlled substance, a state jail felony?
Guilty.
Yeah, guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yeah, I'm guilty.
Okay. Anyone threaten you in any way, promise you anything, or make you plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed this offense of possession of a controlled substance less than a gram?
Yes, sir.
Are you entering your plea of guilty to the indictment today, Mr. Alvarez, because you have any type of delusion in your mind or some type of unrealistic hope of pardon, parole, or leniency?
No, sir.
All right. Court does receive and accept your plea of guilty to the indictment. Mr. Alvarez, what do you have, Ms. Anderson?
Your Honor, we offer states 1, the plea packet with signed waivers and admonishments, states 2, the stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
With no objection, states exhibits 1, 2, and 3 are admitted into evidence. State exhibit 1, all the plea documents. States 2, the signed 1, 2 stipulation of evidence. States 3, approved, admitted into evidence by the court. Court finding all the exhibits under 1, 2, and 3 were done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty to the offense of possession of a controlled substance, state jail felony, as alleged in the indictment, was entered to the indictment freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty, finds it is fully and sufficiently supported by the evidence in the case. However, the court does this time withhold a finding of guilt as to the defendant will move to sentencing. What do you have, Ms. Anderson?
Your Honor, we offer states 4, an electronic copy of the discovery in this case.
No objection, Your Honor.
States 4, electronic discovery, all approved by the court, admitted into evidence without objection. The court in the case then, having received and accepted the defendant's plea of guilty to the offense of possession of controlled substance, state jail felony as alleged in the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty. However, the court does withhold a finding of guilt, follows the plea agreement to recommendation of the state, and essentially the sentence at 5 years, deferred adjudicated probation, no fine, assessed, court costs are ordered to pay, restitution is ordered to DPS, amount of $180 for the lab fee. Any legal reason to vote formal sentencing?
No legal reason, Your Honor.
99, formal sentencing is pronounced. The court receives and accepts the defendant's plea of guilty, finds it's fully sufficiently supported by the evidence, admits into the record. However, the court withholds the finding of guilt, follows the plea agreement, formally pronounces sentence at 5 years of deferred adjudicated probation, orders $180 restitution DPS for the lab fee be made one of the conditions of the deferred. Sentence is formally pronounced. I have from you, Mr. Alvarez, you and Mr. Robertson, a waiver of appeal, waiver of your right to file a motion for new trial. Are you presenting those waivers now to the court through Mr. Robertson?
Yes.
Court receives and accepts a waiver of appeal, receives and accepts a motion for new waiver of motion for new trial. Sentence is formally pronounced 5 years deferred adjudicated probation. Mr. Alvarez, I need to be sure you do understand you're on the 5 years deferred adjudicated probation as of today. The first requirement is going to be explained to you by the court's probation officer, also on the screen, Marcella. This relates to what you do now to go and meet with your supervising probation officer, and it's condition of your deferred to report immediately and directly to the Smith County Probation Department. There you'll meet your supervising probation officer. He or she will go over your 70 or so conditions. Go ahead, Marcel.
Mr. Alvarez, upon being released from court, immediately report to the Smith County Probation Department, which is the same building that you were reporting to pretrial. When you get to the probation department, you'll sign a new from court, or intake officer will come and get you from the lobby, and you'll be assigned a supervision officer today.
Okay.
All right, you understand all that, Mr. Alvarez?
Yes, sir.
All right. Are you satisfied with your court-appointed attorney, Mr. Clifton Robertson, who's on screen right beside you?
Yes, sir.
All right, it's the order of the court then that you are sentenced to 5 years deferred adjudicated probation. If you serve out the 5 years and a portion of it your own deferred for and do not violate any of the terms and conditions, State will dismiss the indictment against you if you violate any of those terms and conditions, like failing a drug test. That's your best bet, bust the probation. If you fail any drug test or violate any other condition of your deferred, state will file a motion to adjudicate your case. That'll cause a no bond warrant to go out for your arrest. When you're apprehended to turn yourself in, there'll be a revocation hearing. It's actually called an adjudication hearing. If the court receives evidence from the state as to the violation, if the state convinces the court you have violated one or more terms and conditions of your deferred, the court grants the state's motion to adjudicate, just a big legal word, meaning the court goes back, finds you guilty of this state jail felony, and then because you were on deferred, the court can assess your sentence up to the maximum 2 years in a state jail facility and a fine of up to $10,000. You understand all that?
Yes, sir.
You satisfied with the legal representation of Mr. Roberson, your court attorney?
Yes, sir.
Anything else, Ms. This must be down to you, Mr. Chandler.
Nothing further, Your Honor.
Anything else, Mr. Roberson?
No, Your Honor.
All right, now, Mr. Alvarez, it seems simple, but I have some defendants who wander off somewhere, but go directly to probation for the probation officer to go over their conditions. So then they just get a no bond warrant issued. So you do know where the probation department is, where you've been doing your pretrial reporting.
Yes, sir. I know.
Your probation officer will be waiting on you. Anything else, Marcel?
Nothing further, Your Honor.
All right, we're in recess.
Thank you, Your Honor.
Thank you,
That's
Mr.
it for me,
Roberson.
Your Honor.